Good morning, everybody. It's January 31st, Friday, 2025. This is a special meeting of the Commissioners of the City of Rehoboth Beach. We're live in the second floor City Hall Commissioners Room. I'd like to call this meeting to order at exactly 10 o'clock a.m. I'd like to start off with roll call. Commissioner Mark Saunders.
Present.
Commissioner Suzanne Good, absent. Commissioner Ed Chernowski.
Present.
Commissioner Patrick Gossett.
Here.
Commissioner Bunky Markert. Here. Commissioner Craig Thier.
Here.
And Mayor Sam Mills is here. We have don't have a full complement, but we have a quorum so we can formally conduct business today. I'd also like to identify some of the staff members that are here today, and that's City Secretary Ann Womack. Wave your hand there, Ann. Thank you. City Manager Taylor Tedder. And Interim City Manager Max Walton. Thank you all for being.
City solicitor.
Is that what you are? Okay. Well, we only have one city manager, and Taylor doesn't need that second burden on him either to be solicitor. Very good. Thank you very much. The purpose of this special meeting is outlined in the agenda. There's several topics there. The first bit of business I'd like to do is thank everybody that's here virtually and watching us. I'd also like to thank everybody that's here in person. Public comment rules are embedded in the bottom of the agenda, so you understand what the guidelines are for making public comment. Our support documents, those are our documents that support our agenda topics, are a complete package for this hearing, both hearings. And they are available on our city website, embedded in the agenda for this meeting. The first bit of business is in the matter of a property located at 330 Rehoboth Avenue. Bear with me, I'm going to read it and only once into the record. The first bit of business is number one, conduct the continuation of a prior public hearing on the subject of potentially amending the Rehoboth Beach Zoning Map referred to at Chapter 270, Section 270-7 of the Municipal Code of Rehoboth Beach, Delaware, 2001, and the zoning district boundaries as referred to at Chapter 270, Section 270-8 of the Municipal Code by potentially rezoning a portion of the property located at 330 Rehoboth Avenue, Sussex County Tax Map Parcel Number 334-14.17-139.00, referred to as the property, from R1 Single Family Residence District to C1 Commercial, Central Commercial District, and to provide a commercial designation to the area of the property currently designated as residential on the comprehensive plan. And there is a follow-up opportunity to consider a vote regarding a waiver of the plus hearing as it relates to the possible change of zoning designation for 330 Rehoboth Avenue. With that, I want to go over what our itinerary is today real quick.
Mr. Mayor, may
Yes.
I feel I should recuse myself from this hearing, so I'm going to do so.
All right. Thank you, Mark. Commissioner. So today's itinerary, after this, I'm going to hand it over for additional remarks by Interim Solicitor Max Walton. After that, we'll resume the applicant's presentation. Number three, we'll go back to public comments. We did entertain public comments at the last meeting. We will re-entertain them at this meeting. We will, after the public comments, give the applicant additional time for rebuttal, if they like, to the public comments. Then at that point, we will close the public hearing and bring it to the commissioners' discussion and possible vote. And we'll likely have a short recess after the public hearing closes. I'm going to turn it over to Max Walton.
So this is a continuation, but we went ahead and followed, it's a continuation of a public hearing, but we went ahead and followed the same notice provisions that we did for the initial public hearing. The agenda for the Board of Commissioners was posted in City Hall on the portal on January 21st. The agenda was amended and reposted in City Hall on the city portal on January 22nd, 24th, 28th, 29th, and 30th. public notice for the public hearing continuation to amend the zoning map and the zoning district boundaries by rezoning a portion of the property located at 330 Rehoboth Avenue from R1 to C1 and amending to the city's comprehensive development plan was posted in City Hall and on the portal on January 7th. Public notices were published in the Cape Gazette on January 14th, January 17th, and in the Delaware State News on January 10th and January 14th. Notification specific to this rezoning request was mailed out to property owners within 200 feet. And I'd ask that Ann Womack just confirm that what I read is true and correct.
Correct.
All right. As this is a continuation, just a couple of matters. I had instructed the commissioners to rewatch what happened back on November 18th. I hope you all had an opportunity to do so we don't have to go all the way through the entire presentation again. I think that was the agreement when this was paused before, that we would just, it's a continuation. That which was in the record before remains in the record. I would note that the agenda, what's embedded in the agenda, includes correspondence and other items that have been received since that time. We received a letters as of late yesterday, but they were embedded. I'd also like to point out that we did a different version of the ordinance, which slightly amended the ordinance that was considered on November 18th, and that was to reference the plus issue. As you recall, the reason that this was paused is that the comprehensive development plan amendment wasn't in there, and so there were provisions added to, basically added to the ordinance to make sure that the plus provisions were addressed. While they're usually done beforehand, the plus issues. In this particular instance, because of this is on remand and it's been here before, and we had an amendment of the comprehensive plan, I called and talked to state planning, who were amenable to a request for a waiver if the rezoning passed, and if they didn't waive it, that gives the applicant time to go to plus if they need to afterwards. So this is with the blessing of the Office of State Planning that we're doing it in the fashion that we're doing it. That's why there's a letter for the second item on the agenda. So if the rezoning did pass, then you would vote on a waiver, on supporting the applicant's waiver of the plus process. But that's not to be an indication that you know, it's a support. It's just a document depending on what happens today. So, Mr. Mayor, I believe that covers everything I had, unless you need me to speak on anything else, and we can turn it over to the applicant.
I think you're fine. Mr. Hutt, would you like to have the floor, please?
Yeah, just while you're walking up, we're starting with 13 exhibits so far, so if you're adding anything, let me know.
At this time, there won't be anything that's being added. I do have, and it's on the screens around the room, these are the same slides that were shown at the November hearing, November 18th. For the record, my name is David Hutt. I'm an attorney with the law firm of Morris James. This morning, I'm representing 330 Hospitality Group, LLC, which is the entity that owns the property at 330 Rehoboth Avenue that the mayor just introduced. With me this morning, the gentleman sitting right next to me is Don Lockwood, and the woman sitting next to him is Leanne Wilkinson, the daughter of Sal and Betty Gallo, and they are the principals of the entities which are the members of the 330 Hospitality Group, LLC. As was indicated in the introduction of this matter, this is a continuation of the prior public hearing. So I'm not going to go point by point, obviously, through all of the materials and such that were covered during the first public hearing. But I did want to provide sort of what I'll call a high-level overview of that. And then near the end of my presentation, I'm going to ask Leanne to make a few comments, and then I'll get back up, and then we certainly be welcome and would welcome any questions that members of the commission here may have. As I'm sure you recall, this application is about the redevelopment of a property that sits at the gateway of the city. This application has a very long history, as we talked about at the last hearing. As you likely recall, the history of it began in 2018 with some meetings with Mr. Lockwood and myself, an engineer, and others, with members of the city, members of the city's planning staff regarding this project. And as you likely recall, the result of that was a recommendation that we move forward and move to the Planning Commission and have a concept review with the Planning Commission. Coincidentally, that concept review took place in January, obviously the same month that we're in now, but in 2019. So 6 years ago, the Planning Commission on conceptual review said that as part of the redevelopment of this process, that the best path forward would be to seek a change of zone as compared to the alternative. The alternative, as you likely recall, is a series of variance applications. And those variance applications wouldn't just be the typical, I need another foot here to meet a setback. There'd be a use variance because, of course, a commercial use is not allowed in a residential district. And then in addition to any use variances, then you would have all of the area variances, the more typical variances that the Board of Adjustment sees on a regular basis. So faced with that question 6 years ago, the Planning Commission said the best path forward for this would be to move forward and proceed with a change of zone application. As you likely recall, that process began. That process was detoured by a landlord-tenant dispute, which ultimately ended with Mr. Lockwood's company owning the property. And then we were back in front of the city moving forward with that change of zone application as had been the preferred methodology to move this forward. Ultimately, the Planning Commission, to our way of thinking, inexplicably reversed course and said that by a split vote of 5 to 3 to 1, that a change of zone was not appropriate for the property, which of course means that it would be a series of variances to use the property. Again, that's a complete 180-degree change in what had been the recommended path. After receiving the Planning Commission's recommendation, of course, we had a public hearing in front of the mayor and commissioners, and ultimately that change of zone request was denied by a vote of 5 to 2. As you know, and Mr. Walton introduced this before, there was an appeal. Initially, it began in the Court of Chancery, then it moved to the Superior Court. Ultimately, the Superior Court remanded the matter back to the mayor and city commissioners, which led us to the November hearing. And then during the November hearing, the discussion began about modifying the comprehensive plan for this property simultaneously with a change of zone so that the comprehensive plan would be consistent with a successful change of zone application. With that procedural background, that brings us right up to this morning, the continuation of the hearing. As you know, and you've seen this before, and I've explained this, this is what you see on the screens around the room is a survey of the property showing the entirety of the property. Obviously it sits at the intersection of Rehoboth Avenue and State Road. Those are what prior comprehensive plans have called the two entry streets into the city of Rehoboth Beach, being SR 1 State Route 1A and State Route 1B. They're both state roads that lead into the city. As you can see on this survey, the improvements are all located on the Rehoboth Avenue frontage, and then the parking for those improvements is along the state road. And I said it, and you're going to hear even more from Leanne in a few moments, that is the only way that anybody that we've ever talked to has remembered the configuration of this property being. Throughout its history, it's always been used in a commercial manner, and it's always been used in the commercial manner that you see on the survey as it's shown on the screens around the room. At the last hearing, we talked about the fact that this property is just a little over 1,000 feet shy of being an acre. A little more than 23,000 square feet is already zoned C1 Central Commercial District, and a little more than 19,400 square feet is that R1 zoning that the request is this morning to change that designation to the C1 Central Commercial District. At the prior hearing, we reviewed this map, which is, of course, an aerial image of the property outlined in red. And I think I've placed the cursor on it, although it's hard to see at a distance. Obviously, you can see Rehoboth Avenue runs from left to right across the top of this excerpt from the zoning map, and then State Road intersects that. And you can see the various colors, and colors are not my strong suit. I think it's a yellow that's along Rehoboth Avenue. And below that, it looks like a red or a purple. You can see is the designation for the R1 area. Behind that, you can see the Scarborough Village, with Building 6 being the one that's right behind the building that exists presently at 330 Rehoboth Avenue. This map also shows that the commercial zoning along State Road doesn't just end with the first part that's adjacent to or parallel to Rehoboth Avenue. There is commercial zoning as you travel down State Road. There's a C3 portion that is well beyond the limits of the 330 Rehoboth Avenue parcel that you see outlined on the screens. The property is used as a Rehoboth office for Mr. Lockwood's company. You're going to hear a little more about the history of the property, and we've reviewed that before. Certainly most notably, I think it was known for being the location of the Seahorse Restaurant for many years. Moving right to the split zoning of the property, as you probably recall, some of you from the first public hearing several years ago, and then others just from the November public hearing, the reason that this appears to have been split zoned over time is just because of how the parcels came together. As we talked about, there are, as you know, there are two primary subdivisions that help to create the city of Rehoboth Beach, one being the Rehoboth Beach Camp Meeting Association subdivision, and then the second being, of course, Country Club Estates. When you look at this tax map, what this demonstrates is in the highlighted yellow area, that is, of course, part of the Rehoboth Beach Camp Meeting Association subdivision that occurred in Rehoboth. And then you have the crosshatched area with the striping on it. That is a piece of land that existed between the original Rehoboth Beach Camp Meeting Association subdivision and the Country Club Estates subdivision. So it's just a piece of land that existed between them. As we'll see on a subsequent plot when we talked about, that was actually owned by a utility at one point in its history. The green portion, triangular portion, is what I would call sort of a remnant or residual piece of the Country Club Estates. As you can see, it has no road frontage, so it's not as though it could be a lot that somebody would access. And so when you combine those three pieces, the highlighted yellow piece, the striped piece, and then the highlighted green piece, that is the parcel. That is one parcel on the tax maps. It's been designated in that fashion for the known history of the property, with the singular owner for again, more than half a century of that. Breaking down into the component parts of that, and one of the reasons I wanted to pause here is because I was asked a question by a commissioner in November, and I did want to clarify that. This is the Rehoboth Beach Camp Meeting Association plot that is recorded. It says plot book, but it actually should be deed book 84, page 602. I was asked about the recording date of that plot, and I believe that unfortunately I may have missed by a century. I think I said it was recorded in the early 1900s. It's actually 1828. This is one of the original subdivision plots that created the city of Rehoboth Beach. And as you can see, highlighted sort of in the central bottom portion is the portion of that subdivision plot that is part of 330 Rehoboth Avenue and is actually where the structures are located today. You can also see that when this occurred in 1828, the State Road, or Old Bay Road as it would have been known then, was not intended to connect all the way to Rehoboth Avenue. That's a change that occurred since 1828 over the history of that. The second plot subdivision plot that we mentioned was the Country Club Estates, and that is recorded in plot book page 80. And again, you can see that I've highlighted that triangular shape that has no road frontage, and so it would be a residual piece from that. And actually, there's a reference you can see to that utility, the Eastern Shore public utility piece that existed between those two pieces of land. Again, that history is important just because it demonstrates probably the most likely reason why this single piece of property has had this commercial use, and it's never been something that was brought to anyone's attention. It grew together over time, beginning with Rehoboth Beach Camp Meeting Association, the utility, and then the Country Club Estate residual piece. But significantly, while it is one parcel, again, you'll hear this, and it's a common theme, it's only ever been used in a commercial manner throughout the history of this property as it's been assembled over that time. The significance of all of that, of course, if the Seahorse Restaurant were still open today, we would not be standing here, I would not be standing here in front of you, and this probably wouldn't matter at all because that use would just continue. The question, though, is, and this is why I started with the statement I made at the very outset about the redevelopment of this property. The question is, how does this property get redeveloped, and the best path forward for that redevelopment? And we've talked about this several times, but as the commissioners are likely aware, the split zoning of properties is disfavored both as a land use principle. If you're a land use planner or engineer trying to design something, that is a disfavored principle. And that's because of the many difficulties and issues that arise. As I mentioned last time, there's no provision in the zoning code that says if you have a split zone property, this is how it gets treated. And logically, it's because those zoning classifications are not hard and fast lines on a piece of property. They're imaginary lines. And so as a redevelopment project for this piece of property, as you move forward, of course, you get to that imaginary line on the piece of property, and what happens? Well, the types of uses in this case change. That's not always the case. If, for instance, if both of the uses were commercial, then they might have overlap in their uses that are permitted uses under the code. In this case, they are different and distinct. Of course, there's a commercial zoning classification and a residential, so the uses are not even the same. Well, of course, that means, and there was an initial memo that Mr. Molina provided, again, probably almost 6 years ago at this point, about the nature and types of variances that would be needed. So initially, as a threshold issue, there would have to be a use variance to say that the residential portion of the property could be used in some commercial manner. Then, of course, that leads to, assuming that's successful, that leads to a series of questions about, well, what are the bulk area standards, the setbacks, the floor area ratio, because at that imaginary line on this piece of property, all of those things change. And so then you have to try to put those things together. And as you can imagine, that's going to lead to very novel and unique issues that are difficult for everyone. They're difficult for the property owner to figure out how to plan and utilize their property. Difficult for neighbors of the property who don't really know what the permitted uses would be for that piece of property, because there's going to have to be those variance applications that come forward for use, and then, of course, also for any area type variances that are necessary. It's difficult on the city's staff as it moves forward and it tries to apply its zoning code to that piece of property and the redevelopment that goes on. And again, that's why what occurred 6 years ago with the Planning Commission makes sense as a matter of law, makes sense as a matter of land use planning, that you would have one zoning classification on a piece of property so that all the parties who are interested, owners, neighbors, the city staff, everyone would know how to move forward with that piece of property without having to go through a series of variances. One of the goals of any redevelopment of a property is to minimize or reduce the number of nonconformities. It's not surprising, the city of Rehoboth Beach has many things that exist and properties that exist that were developed prior to there being the current codes that exist. And so there's a number of nonconformities, but as those things are being redeveloped, the goal of those things is to try to reduce nonconformities to the extent possible. Certainly there are instances when that is not possible. But in this case, if there's not a rezoning, when you redevelop this, the number of conformities increases because of the use variance and the area variances that are involved with that. The executive summary that existed within the 2020 Comprehensive Development Plan talks about that the city should continue to consider opportunities for redevelopment of commercial properties, and goes on to talk about being subject to the overall planning goals set forth in this CDP and the city code, especially their provisions requiring compatibility and consistency with the city's existing small town scale, architectural character, and pedestrian orientation. And that's a good description of what is intended here, and also what is provided for within the code itself already. Now, the code has provisions that state what happens when a commercial property backs up to a residential property, what exists or what needs to occur in that circumstance. And the city has a site plan review process and a planning commission that performs vigorous reviews of site plans as they move forward through that process. And that's how the city achieves through its zoning code to make sure that there are compatible uses. That you're going to hear from Leanne again in a few minutes about values and how commercial and residential can interact with that, and how that can impact property values. As you recall, the city planner looked at this, and one of the statements from the city planner's report, again, this is several years ago, but Mr. West's report states that on the cursory review of the current CDP policies, a change to C1 could be consistent with the policies promoting revitalization in corridor and gateway areas, but could exacerbate concerns related to impacts to the adjacent residential areas. And that highlights that issue I just mentioned. That compatibility is accomplished through the zoning code and through that site plan review process. And then looking at what the issue that arose in this past November regarding the state strategies process that exists and the designation of this property on the future land use map. When you look at the future land use chapter in the city's comprehensive development plan, you would see that, not surprisingly, almost the entirety of the city within its limits is all level 1, or what state strategies refer to as a level 1 strategy. There are very limited areas in the city that are not. And level 1 is significant because those are areas that the state thinks are appropriate for the highest level of contribution from the state, and the state is going to support growth or redevelopment within those areas. Of course, that makes sense as, one, it's a municipality, and so it makes sense for the state to say our strategy is to support the growth of municipalities within the state. But it makes sense on this particular property when you look at all of the various maps that are within the city's comprehensive development plan. There are, as we've mentioned several times, 2 state roads that this property abuts, Route 1A and Route 1B, State Road and Rehoboth Avenue. There is public transportation. Both of those roads happen to be on public transportation or dark routes. And so from a state strategy standpoint that is within the comprehensive development plan, you can see that this is a property that it makes sense to have a commercial zoning designation that matches the historic use of the property. At this time, I'm going to ask Leanne if she would make the comments that she wanted to make, and then I will probably just have 1 or 2 concluding comments after that.
see the email that got sent late yesterday afternoon.
Thank you.
I'm not going to put any of these in the record because they already went in onto the portal and they're already part of the record.
There's some pictures in here and stuff that
Every,
were not in my email last night.
all right, well, then I'm going to mark your packet as Exhibit 14 then,
Just the entirety of it?
the entirety of it.
So, hi, everybody. I'm Leanne Wilkinson. I'm a local Realtor, and hopefully most of you recognize my face and my name. Otherwise, my marketing's not working very well. I'm also the daughter of Betty and Sal Gallo. My parents are longtime respected members of the Rehoboth Beach community. Our family has owned several businesses all on Rehoboth Avenue, starting in 1970 with the Yellow Submarine, which was a place that I worked starting at age 12, which was located Ocean Block by the Farmers Bank, if anybody remembers where that was. And now, at the other end of Rehoboth Avenue, they own the Berkshire Hathaway Home Services office at 37230 Rehoboth Avenue Extended. My parents were both realtors, but my mom focused on commercial real estate in downtown Rehoboth. For many years, she was the go-to realtor for everything commercial in Rehoboth Beach, both sales and rentals. She was also a founding member of the Rehoboth Beach Main Street, and for many years, she served on the board of directors of that group and was named Citizen of the Year in 2009. I'm very new to this whole proceedings, and I think several of the people on the commission are also new to this. The November 2024 meeting was the first one that I attended, but as David said, this has been going on since 2018. So I'm here representing my parents, one, because they're in Florida for the winter, and two, because they are now 92 and 88 years old. And I have to say, my sister and brother-in-law are here, my husband's here. None of us can believe that this has been going on for over 5 years. So it's been kind of crazy, but I haven't been involved until November of last year. So prior to purchasing the property with Don Lockwood, my parents did their due diligence. They met with attorneys, engineers, and city officials, as David said. And at the time, all the indications seemed that the way forward with this was to go for the zoning change. That was the preferred method of getting this done. And the reason I think for that, and why the city thought that, and why the attorneys thought that, and why the engineer thought that, is because this property has never been used as anything but commercial. So 330 Rehoboth Avenue is presently Don's office, or one of his offices. Prior to that, from 2002 to 2017, it was Ocean Atlantic Realty. Before that, Chili Billy's, Donardo's Crab House, and I just turned 65. I worked at the Seahorse Restaurant when I was 15 years old. So that's totally easy math. 50 years ago, I worked at this building. And I hope all you remember the Seahorse. Seems like some of you would, and hopefully you all ate there and remember it was just the place to go if you had a special occasion at the time that I worked there. And also, you know, the Rehoboth locals were always there Friday night. There was the Lin Ang Trio that played the music, the free oysters with all your dinner. So it was a very popular place from 1970 to 1996. So I kind of remembered that there was another restaurant before that. Being a little kid, I kind of remembered that. So I couldn't remember what it was. I called Kitty Cole, who I think many of you know as, I think, the oldest Rehoboth native at 101 years old. And she's still very, very sharp, by the way. I said, Kitty, do you remember what it was before the Seahorse? And she said, yeah. And she named right off, it was the Horse and Buggy. And the Horse and Buggy was owned by a guy named Bill Brooks. She told me that. But she went on to recall that prior to the Horse and Buggy, 330 Rehoboth Avenue was Gundry's Restaurant. Alice, I did not know this, Alice Gundry and her family owned one of the other Rehoboth landmark businesses, the Corner Cupboard Inn and Restaurant, from 1935 to 2010, but they also owned a restaurant in this location. Before Gundry's, Kitty says, it was Zip Rice's car dealership. So this property was a car dealership way back when. I don't know, she didn't know the exact years, but she recalled all of this. And I said to Kitty, do you ever remember there being anything residential on this property? And she said, of course not. But just in case there was any question, I had my attorney, title searcher, search the title to see if she could find any residential uses on any of this property, and as far back as she could go, she couldn't find anything. And I know that David did that, and he just gave you that whole history too, but I wanted to do it for myself because, like I said, I'm just kind of late to the game here. So yesterday I sent the city manager and copied all of you some things, and I brought a packet for everybody. In the packet is 3 letters of support, and then I did sort of a petition because that was the easiest way for me to figure out how to do it, that I had signed by 22 of the owners of 22 of the 26 properties, that if you stand on Rehoboth Avenue and you look this way, and across the street, you can see these properties. So I went 1 block towards the circle, 1 block towards the beach, on both sides of the street. I did not call the residences, the individuals in the ARC. I did not call the M&T Bank. I did not call the City of Rehoboth Chamber of Commerce, and I did not call Verizon. So those are the properties I didn't call. I called everyone else, and I was really pleased that most of the people had read about this, knew what was going on. Most of the people were surprised that, again, they remembered that it's always been some sort of commercial business and nothing else, and that we were still trying to get this portion of the property zoned commercial so something can actually be developed on this property. So you should have that. People, the Reeds, Debbie and Bob Reed signed, the Calgione signed, the Draper signed, and there was no question about this. I started working on this 2 weeks ago. And I know if I had had more time, I could have gotten hundreds of more signatures. Nobody didn't want to sign this. And that's really pretty, I think that's pretty impressive. I had 4 people initially say, we're gonna sign. After speaking to their attorneys, they said, Leanne, we really would like to help, but we can't sign because our attorney does not recommend this. We don't want to get on the wrong side of the city. But you have a map of, in your packet, but it's really small, so I brought this. I made it bigger. And if you can see all the green on there, the green are the people who signed either wrote their own letter or signed the petition. The yellow are the people who said they were going to sign, but after speaking to their lawyer, decided not to sign. And the red, the purple is the subject property, and the red, as you can see, scattered throughout, are the people that have opposed it. I researched back to the beginning on this. I found 12 letters of opposition, and those are all on this map that you have in your packet. So let me see if I can get back onto my track here. Let's see. So in reading everything, and I really tried, and I have Elaine here from my office who helped me read everything, because there was a lot on this over the last 5 years. In reading everything, the thing that I saw was, for potentially why some of you that were on the commission before voted no, was because there was widespread opposition to this. And when I realized there was 12 letters, I didn't quite think that that was widespread. And that's over a period of, like I said, 5 or 6 years. And in 2 weeks, I have 22 signatures from people that are supporting this application. And they are literally all something within eyeshot of this property. So the other comment that I sort of read through newspaper articles and things, that this is gonna like change the complexion of the neighborhood. So yesterday, I went and stood in the parking lot and looked across Rehoboth Avenue and across State Road, and you all have pictures there, which I don't, it didn't get sent in the email last night. But I have pictures of one view, and what you're looking at here is standing in the parking lot, looking across State Road to the back of Rigby's, dumpsters, the Verizon building. I mean, I think the VFW, that's your view from the parking lot to State Road. Your view across Rehoboth Avenue, you've got a set of condominium office buildings. You've got somebody's big, yeah, sure. Oh, I'm sorry. Who said that?
And it.
Oh, hey, oh, sorry. You've got like a big solar panel thing on somebody's roof at the, I mean, that you can see, and of course, you see the 5-story ARC condominium building. So that's 5 stories. I think the zoning now allows only 4 stories. So anyway, various pictures of what you're seeing from this. Oh, and you also see another 5-story condominium, which I'm trying to remember the name of right now, that I can't, on the corner of Sussex. So the goal. So anyway, that's that I thought was kind of important, because it isn't the prettiest sight when you look across there from this property. The other thing that I thought was, or maybe read, again, I read so much on this, was that the surrounding property values would be affected. And since I'm a realtor since 1986, I feel like I really do have a handle on property values and what makes them go up and down, and what would be detrimental and what would not. And honestly, I really did a lot of driving around, and honestly, I feel like this property being redeveloped to something on the caliber of what's happening and has been happening in Rehoboth for the past 10 years will do just the opposite of hurting property values. I think it's going to help everybody's property value. And I know that there is a few residential, there's a little point at the back of the thing there that you're touching some houses there, but I feel like, as David said, knowing what can be done and following the rules that commercial zoning has is going to help everybody know what can be done there and expect to know what's going to happen and how that's going to affect them. I brought a couple of houses, well, I went down Sussex Drive because Sussex Street, from 86 to 102, every one of those single-family homes backs up to commercial zoning on Rehoboth Avenue. And I wanted to just, hey, you know, what happens there? So there were, in the last 5,000 days, there were, I think, 5 houses that have sold. One sold 2 times, and that's the one that I think is the most important. It's 92 Sussex. It backs up directly to the ARC. It sold in 2017 for $1,665,000. Without any substantial change, last year in June, it sold for $2,700,000. And that's 92 Sussex, and right in its back, you look up from the backyard, and there's the ARC. So it's a 5-story building. So I don't think you can get any closer to a commercial building with your single-family, beautiful house. This house is beautiful, and it had no trouble selling in 5 days. That house was on the market for 5 days. So I think that's my support of it. I do want to say, you know, my parents, of course, are very nice people. They've been active members of the Rehoboth Beach community for over 50 years. for sure, in a very short period of time, it's documented that I was able to get double the support for this application than against it for the last 5 years. For sure, the application's gone on way, way too long for whatever those reasons may have been, and it's made a financial impact on my parents and Don. But the reason, in my opinion, that you should vote yes on this is because this is a very unique piece of property. In 41 years that I've been selling real estate, I do never remember seeing a single parcel zoned with 2 different zoning designations. 1 parcel of land, 2 zoning designations. It's just, I just never saw it before, and I've seen a lot. So it's unique. It has 1 address, 1 parcel, 2 zoning classifications, and it's never, ever been used residentially. So it's strictly been commercial for, we kind of just proved here today, at least 75 years, maybe more. And because we don't know the dates of some of those restaurants and the car dealership. And it's an eyesore right now. It looks terrible. You come into Rehoboth and this is what you see. And I think that this property is at the gateway of the city, and it could be something, and it deserves to be something really nice. So when you're driving into town, you see it and you go, wow. Just like when Lingo rebuilt their building, and you drove in the first time when it got finished, and it was all done and yellow and green and beautiful with the lights on it, you were like, wow, that's a nice property. That's what this property deserves to be. And I think this whole end of Rehoboth Avenue is kind of like screaming for redevelopment, but no property more than this one. So I feel like you guys should vote yes on this. That's my story. Thank you very much.
Ms. Gallo, Mr. Hutt, you read from some property sort of information. Did you want to put that in as part of the record?
Which, you mean these?
Yes.
I didn't copy it, but I have 1 copy.
That's, if you give me your 1 copy, I can make it part of the record, or I can not.
There you go.
Right.
You can have it.
This will be 15 then.
15. Yep. You have to get your own copy, Mr. Hutt. All right, thank you.
Just, I'm not going to belabor that any further. I thought Leanne said it very well. Today's request to the mayor and commissioners is to fulfill what was set in motion 6 years ago. And we request that the change of zone for the balance of the property that is presently zoned residential be changed to match the other part of the property, the C1 Central Commercial District, and likewise to finish be able to finish the process with the Office of State Planning Coordination. The request is, of course, that the second item on your agenda under the 330 Rehoboth Avenue, that letter that Mr. Walton prepared be issued by the city supporting a waiver to the Office of State Planning Coordination. Certainly myself and Mr. Lockwood and Ms. Wilkinson are happy to answer any questions that the mayor or commissioners or staff may have.
Thank you. The next step will go to public comment, but before we do that, I would like to invite the commissioners to ask any questions of you. Anybody?
One
Commissioner-
clarification.
Commissioner Gossett, go
Thank
ahead.
you. The parcel number that you're referring to, that is a county parcel number, correct?
That's correct.
Not affiliated with the city's records at all.
I think the city uses, I mean, I agree with you that it is a Sussex County tax parcel number as it exists in every municipality and throughout all of the unincorporated areas of Sussex County. But this city, I mean, I think the city uses those tax parcel numbers just like the county does. I know that there is, for instance, when you look at the Rehoboth Beach Camp Meeting Association plot, you can see the various parcel numbers. I can't read them from here, but you can see the various individual lot numbers from that original subdivision plot for the 50 by 100 sections of that. But again, the property has not been known in that fashion for, again, the known history of the property. It has not been known as anything other than being 1 parcel of land. It's been all those various component parts that we talked about, those 3 component parts, I believe that people would refer to that as having been merged by use for, again, at least 3/4 of a century, but perhaps longer than that. So.
Thank you.
Any other commissioners? If not, then we'll go to public comment. As the agenda indicates, we invite public comment, 3-minute limit. There is a clock up there if you keep an eye on the clock. But we welcome your comments on the topic. Mr. Cole? Yes, sir. If you come to the front microphone here, and anybody that comes up, we're going to ask you your name and identify yourself with what your relationship is to the city, please.
Okay.
Mother of, or
No.
son of.
Well, I'll end with that one. George Cole from Ocean View, Delaware. And I don't live in Rehoboth anymore. I haven't lived in Rehoboth for many years, but I still have an interest in the properties on, family properties on Olive Avenue. So my background is, for 40 years, over 40 years, I've had a real estate license. So I have a little expertise in real estate. And also, I spent 32 years on the Sussex County Council, which dealt with a lot of these rezonings like you're talking about. And over those years, I probably had a reputation for voting no many times because I was concerned about what was happening. But I also voted yes very many times. Probably as many times as I voted no, I voted yes. And I did that because they were reasonable requests. They had a historical background of use. And the area, I looked around, has the area changed over the years? And obviously over the 75 years that this has been a parking lot or more, things have changed. And Rehoboth has changed a lot from the way I can remember. So I feel that this split zoning is a problem. I concur with everything Mr. Hutt said and even Leanne. So I think that their argument that here for 6 years this has been dragging on makes no sense. We've seen where, common sense ought to come into the play here. So when you've got such a history of a property in an area that is so commercialized, and then plus that intersection is probably one of the busiest intersections in town, so I can't imagine how many people would really want to live there and have a residential home. So I think the highest and best use is rezoning it. The split zoning is no good. Variances are no good because they're just awkward. So I would say keep it simple, rezone the property, and then move forward, and hopefully you get a nice project. The Gallos, I actually have had a real estate license with the Gallo family. I've known them for over 50 years. I think anything they tell you they're going to do, they'll probably do it. So that's all I can say, and I don't have any comments from my mother right now. She did say Leanne called, and that I would see what I could do, and she actually says the same thing. She sees no reason why this isn't rezoned. So I would say move forward and try to adopt this as a rezoning. So thank you very much. Anybody got any questions?
Thank you, Mr. Cole.
Thank you. Oops.
Any other member of the public? This is your opportunity. For those that have spoken before, we want you to know we recognize you and your letter, and so hopefully you present something new today. Go ahead, your name and relationship.
My name is Lynn Shrivastava, and I have made public comments before. I've been involved in the proceedings here over the last 5 or so years, and I just wanted to reiterate that when we talk about supporting the development, I think everybody that you would talk to would say they'd like to have that building, that dilapidated building, replaced and have it developed in a beautiful way. I think the distinction we're trying to make here is that we would like to see that improved, okay? But at the same time, the concern is that you can develop this property using the parking lot as it was versus having a commercial for the entire property. You could have a lot of things that could be built there under a commercial classification. So I just wanted to reaffirm that there are many people specifically in the Scarborough Village community that are adjacent to the proposed property that's being proposed to be developed. And we have concerns about it. And, I appreciate all the homework and how, long it's taken to get where we are here today. But there's a reason why we are here today and why it's taken as long as it has. And it's for the purpose of doing the right thing. So thank you very much.
Thank you, Lynn. Anybody else? Mr. Srivastava? Again, start off with your name and.
My name is Saurabh Srivastav. I'm Lynn's husband, and I spoke last time also. Just wanted to remind you that we have owned a unit in Building 6 of Scarborough Village for the last 43 years now, 42 years, I'm sorry. And there are 8 units in that building, and 6 of the 8 owners are original owners. And in my opinion, that's the building that's going to be most severely impacted by the rezoning. And the rezoning, however it's developed, it's going to cast a shadow on Building 6, both literally and figuratively. And when we bought, it was on, the seahorse was flourishing at that time, and this was a parking lot. And we just made the assumption that it will always remain a parking lot and not get rezoned. So I just wanted to, that was our premise at that time.
Thank you,
Thank
Mr.
you.
Srivastava. Anybody else? This is a public hearing, so we're anxious to hear from you. Anybody else? Yep, there you go.
I'm not a public speaker,
So
so I'm
state your
just going
name
to
and
do my best. I'm Donna
relations.
Boswell. I have a house that abuts the parking lot. And I think the same way a lot of the residents of that area feel that it would be a negative impact on our community to put a potentially 4-story building right at the line. I wonder if there are ways to move forward with an appropriate project that would beautify our community that might leave that small corner not built upon. I feel like compromise might be a way to continue to make a great new project without destroying every area of green that's near our homes. Thank you.
Thank you. Anybody else? If not, we're going to close the public hearing portion. Before I close the public hearing portion of this, I want to come back to Mr. Hutt and the applicant, see if, is there anything additional you want to say resulting from the public comments?
Just very briefly, we've heard from the Scarborough Village individuals, and to their credit, they get credit for time served because they've been consistently at almost every one of these meetings and hearings over the course of the last 5 or 6 years. But I would say that Building 6 is probably almost the least impacted by the change of zone, because that's the portion of the property that already has the commercial designation. And so that portion of the property could stay, they could revitalize or just refurbish the building that currently exists there. But that building could also be removed and a compliant building with the C1 portion, again, put an imaginary line, as we talked about earlier, on the piece of property. Whatever the code allows to be on that piece of property under the C1 designation could exist there. And again, that's why I referenced that building. If you look on the screens, you can see the Scarborough Village condominiums is shown there. And you can actually see you can see the location of where that building is with respect to the existing building. And so again, I think the change, of course, would be to the other portion of the property that moves further down State Road away from building number 6. But again, this is, the request is the same. And again, there's the historical use of this property, again, for the entirety of the known history of this property supports the change of zone request so that this property can be redeveloped and be an attractive entranceway at this gateway entrance to the community, to the city. Thank you.
Thank you, Mr. Hutt. With that now, we'll close the public hearing portion of this and bring it back to the commissioners. Would commissioners like to have a short recess to contemplate? Yeah. We'll
Just,
take
and my
five-
usual instructions, don't talk about this while you're taking your recess.
I just need to put together all of my thoughts into
That's fine. Just don't,
what needs to be articulated.
don't talk about it, that's all. Thanks.
So we're now in recess. We're going to reopen the proceedings. We're at the point where commissioners are going to discuss up here. We have closed the public hearing, so the only discussion will be up here among the 5 commissioners, and open to say anything they want, and at some point offer a motion one way or the other. We want to remind everybody, or maybe you want to remind everybody, that because this is a zoning matter, that we need to give rationale for our vote when we come to that point.
That's correct. So, Mr. Mayor, you're required to state the reasons in the record and for your vote, which means the testimony and the public documents that have been put in. That's why I ask about the exhibits, and we put all kinds of exhibits in that are in the record. There's no formal burden in a rezoning hearing, but the applicant has to make its case. And again, while zoning is a legislative act, you have to state the reasons why, based upon the record and the facts presented, that the factors are met or not. And I've provided you a long memo on that issue.
So I'd open it up to the commissioners for additional discussion, if you'd like to share your thoughts and/or
Can I,
provide
Max,
a
can I ask a
motion.
question?
Yes, sure.
Um,
Commissioner
If we
Szymanski.
make comments now, can we incorporate those into our, I don't want to reread.
Understood. Yeah, the answer is
my rationale.
So let's say you went on sort of and said, this is what I think, right? And then when you made your vote, you'd say, for the reasons I previously stated, which are incorporated herein, that's why I voted this way.
Thank you.
Or you can reverse also.
Yes, you can do it in reverse also.
But if I do it beforehand, maybe I'll change minds.
That's why you get paid the big bucks.
Well, I probably want to do this in 2 sessions, I'm mindful that we're here because we're remanded by court to clarify rationale for our previous votes. There was a different composition of the Board of Commissioners at that time, so we're starting over again, and they are allowed to participate. There is an opportunity, of course, for this meeting and this vote to reevaluate our vote and offer more precise rationales, as Max Walton indicated. I really don't find a lot of new content. It's largely representing the original stuff. So I've had to reflect on a couple things. What's new? Well, the future land use map is unaltered relative to this topic and proposed rezoning. But there is a new path identified going forward. And we will be addressing this as item agenda number 2 later on if this goes a certain way. What is new this time is reliance on the 2020 CDP instead of the 2010 CDP. What also is new is additional correspondence. It almost doubled. The correspondence, as I'm just approximating, it's about 50-50, 50 yes, 50% no's. Although of some of the new correspondence, there is a small percentage or a percentage that says no to zoning, but they say the right path is going in front of the Board of Adjustment. And there actually was somebody that said yes to the rezoning, but also go in front of the Board of Adjustment. The Wallace Montgomery, I just want to read a statement from Wallace Montgomery's report dated August 30th, 2021, that had great influence on me. And that is that the application was considered by the Planning Commission at their May 14th and June 11th, 2021 public meetings. Deliberations at the meetings included concerns over recommending rezoning due to the possibility it would result in C1 uses other than a hotel, motel, inn occurring at the site, with resulting impacts on adjacent residential areas without additional limits. Further, Wallace Montgomery states these are our subcontracted planners. Further states that zoning change proposals typically require evaluations of relevant policies described in the adopted comprehensive development plan and related conditions in the immediate area. In addition, the scope of the land use review must consider all possible outcomes as a result of a potential zone change as opposed to addressing just a specific site design. Further, he goes in here and he just articulates or reminds us of permitted uses in the R1, which are single-family accessory uses, signs and tilling of land and allowed in R1 district. But he also articulates or points out that permitted uses in the C1, if we change this to C1, would include all those residential uses, including two-family dwellings, single-family dwellings, garden apartments, etc. But also in a C1, a Tier 2, a hotel, motel, or inn is allowed. And a Tier 3, well, all these again are allowed in a C1 district, is fire station, automobile parking, retail stores, theaters, billiard, pool rooms, printing, engraving, hand laundry, gymnasiums, etc. So, I struggle a little bit on the how to value the conversation that for 50 years this has been the back residential lot was used as a parking lot. That's true, but I don't know whether that was proper or not. If it would carry more weight to me, I think if that R2 lot had a two-story commercial building on it for 50 years. But again, it was residential, so I'm struggling with how to interpret that most of the letter writers for Leanne and Mr. Hutt mentioned that that the R2 has had parking on it for 50 years. Again, to me, that is significantly different than having one of these Tier 2 or 3 commercial uses on it. The reference to the CDP, remember now we're using the 2020 CDP, not the 2010. They do have some common occurrences on there, but one thing that I focused on was Chapter 4, land use and annexation, and action items. 2 action items caught my attention. Ensure the city's land use plan and zoning code are drawn to avoid any adverse impacts by commercial development upon residential neighborhoods. And number 2, actually letter F of the action item, consider rezoning any currently permitted commercial uses or categories of use that have clear potential for adverse impacts on residential neighborhoods. It seems that if that residential area was already commercial and there was nothing on it other than parking, seems to me that would be a candidate for this one, that we might consider rezoning that residential to get rid of adverse impacts. So I don't know how to weight the 50 years of parking on that area, because again, allowing that to convert to commercial allows a much greater, higher intensity of use. So I go back to, one of the things I go back to is the Planning Commission when they first heard. And Mr. Hutt reported that the first time they looked at it, they suggested a rezoning. And yet they had second thoughts. So the second time they recommended variance through variances, plural, through the Board of Adjustment. I have indicated before that I find, and I still find, that both lots, the residential zoned area of that lot and the commercial zoned area of that lot are both, can be made reasonable use of them. And I believe, I do believe the rezoning would have a negative impact on the abutting residential properties, based again on the potential commercial uses that are higher intensity. I'm concerned about changing that to commercial and its impact, and I think it's a negative impact on light, air, and noise. Light meaning that there will be shadows cast, and air meaning obviously if there was a single-family house there, they'd have greater setbacks than what the commercial property would have. So I think, and the height can be higher for the commercial buildings than it can be for residential. And then noise, obviously just the noise of a hotel or any of those other higher tiered commercial uses give me a little pause there. I, as before, I indicated before that as it was mentioned by one of the Scarborough Village owners, that they might be okay with you just keep continuing with parking there. And my comment was that I personally, I would be very amenable to if they tore it up, put some underground parking and restored the on-ground parking type thing. But that's not something that would be addressed other than perhaps through a variance. So I hesitate right now, maybe my colleagues can sway me to support a rezoning, but instead suggest that the applicant go back to go to the Board of Adjustment. I stuck my neck out. Next.
I'm going to challenge you, Mayor. So the first thing you talked about was about the several planning commission meetings that had happened, and where we're at today is because the applicant acted in good faith, listening to the directions that they were given by the planning commission. And in January of 2019, the planning commissions told them that this was the proper route to go. And it was only later in 2021 that there was a change in that directive from the planning commission after this process had already been started. Furthermore, it was presented in evidence that talking about putting certain conditions on the property, the applicant in good faith and effort offered to put restrictive covenants on the property that would be acceptable to the city, and the city rejected those. So I think we have before us an applicant that has done everything that the city has advised them to do in the right manner and in the right way, and that needs to be taken into consideration. And Mayor, you also just talking about the existing 60-plus years of it being used as a commercial parking lot, how you might, you put a little bit of value into that, but had it been a two-story commercial building, you'd put more value in that. But both are permitted as C1 uses, so why would you put more value in one than the other? I'm just playing the devil's advocate here.
You're not interrogating me. But I hear you.
And you have mentioned the possibility of it having an adverse impact. There has been absolutely no evidence documented by anyone in the course of 20 years or 60-plus years, that there has been any adverse or detrimental impact on the current use as a commercial parking lot, which is a C1 permitted use at all. And you talked a little bit about there being more support today in letters But what is more important than, yeah, there's a little bit more of letters of support is the lack of opposition. There needs to be some value put on that. I put considerable value to that. And those are just a few comments that I had from your statements there.
Fine, thank you. I think you make a compelling argument, actually. You know, I used to live behind commercial, and a lot of my neighbors on Maryland Avenue, first and second block, have commercial behind them. And so I think, Leanne, you also make a compelling argument, I think, to show how the values of abutting up there, not that anybody necessarily would choose that over a non-commercial lot behind them, but I think that has some validity. So I'm looking for opinions from the other side, or joining in Ed on his. Anybody?
I'll do my deal, I guess. I think, first I want to thank everybody, who obviously the public and obviously the applicants for providing, I think, a lot of background, a lot of various viewpoints that they have that I don't necessarily would have seen or maybe contemplated, and I appreciate that. I would say certainly. First, I will share that I am part of the state road community. I'm farther down the road, maybe a little more than a quarter of a mile in Schoolview, but I have two properties that both are the sides of them are one state road, and I travel state road, and I have a sort of connection to state road for what it's worth, and. To me, the crux of this, I mean, I think it's very interesting to hear the history, the history of the parcels, and something I'm certainly interested in, and like how Rehoboth got to be what it was. And I don't have any connection to the Seahorse restaurant or any of that kind of stuff. That was before my time. But I've been here 20 years, going on 21 years now, and I've certainly seen a lot, but obviously so much more has happened, before my wife and I arrived. But the decision for me, as much as you can talk about what has been, I think we have to deal certainly what we have now, and more importantly, I think what's in store for the future. And to me, that's what the decision is. It's not to me, how's it going to affect, how's it going to affect the immediate neighbors and all this other kind of stuff. I mean, that certainly is meaningful, but I'm really looking down the road in terms of how this impacts what Rehoboth is and shall be. And I think that there are so many various things that are included in that, but I still go back to the fact that I think this is a unique situation because it is at a juncture. We have this juncture of commercial property abutting residentially zoned property. The residentially zoned property obviously has not been residential in a residential way, or at least from what everyone has described, not in any kind of recent time frame. But I see it primarily as a give and take, or I guess a zero-sum game where what the applicant is asking for, to benefit them, and the transaction is, you benefit us, and we'll develop this and make this into a wonderful improved experience and presence, in the city. Granted, and I accept that, but at the same time, at a cost to those surrounding and immediate neighbors who, and depending on where their proximity is to relationship to the parcel, some knew it was commercial when they bought it, and it's remaining commercial when they bought it, but the other folks, had some reassurance that what they abutted was residential, and there was no indication to say that it was going to change. So we're in a position now to change that, and I'm just trying to come up with what's the compelling reason, and what's the compelling benefit, overarching benefit that overarches or negates the detriment that they are going to experience potentially or assuredly, and ultimately how does the city benefit? So that's how I see it, and I see it that I don't see how. I mean, one thing I feel like I'm not assured of is how will the developers be able to sort of exercise their vision or whatever with the zoning remaining the same, and can they do that? And I think the voice of many people, especially the adjacent neighbors and so forth, are very positive about that. They would like it to be better. They would like it to be improved and so forth, yet at the same time to not be a detraction to them, to their experience and how they, their experience with living adjacent to it. So that's kind of where I'm at, so.
Well, don't count your vote until
I'm not. Okay.
till I finish, because
Okay.
I'm listening to all aspects here. I'm leaning toward Commissioner Shanowski's comments, but I think I did not mention, I think probably one of the biggest problems that we have is it's a split zone.
Mm-hmm.
And I think that by rezoning, it resolves that split zone. And I think we do have the protection of the site plan review by the Planning Commission. And that's the way I'm leaving. So, Commissioner Thier.
Sure. So I'm going to cover a couple of things from the first set of comments that you had that, I had come across. The first one was your reference to the CDP and the section on commercial, the section on commercial controls, which is located on page 412. And specifically, you had quoted, I don't want to say you quoted, but you had referenced, and this is what it says in the CDP, because of the close proximity of many residential and commercial zones, avoidance of adverse impacts of commercial activity upon residential neighborhoods should be a high priority in city land use decisions, right? So that was one of the ones that you had mentioned. And if I misinterpreted you, I apologize for that, but that is certainly one of the things that I see within the CDP, okay? The second thing as I go through the 2020 CDP is that, the rezoning of this parcel from residential to commercial, it's not addressed, right? It's not referenced for rezoning at all within this entire document. So again, if I'm going to come back and I'm going to take this 2020 CDP or any CDP at face value, which is that it's land use plan, it is the city's land use plan. It doesn't call for this to be rezoned, okay? In terms of, items, and I don't want to say items, but in terms of getting into some of the specifics as it relates to rezoning this from residential to commercial. So, it's going to have a negative impact, right? Because if we go to, as you had stated, and as is the case, if we go to commercial, there are a wide variety of things that whether it's this owner or the next owner or subsequent owners can do with that piece of property, right? So for example, they can essentially build lot line to lot line and go up 42 feet. That's going to have a negative impact on the surrounding neighborhoods, adverse impact on the surrounding neighborhoods, something that it says in the CDP that we are supposed to avoid. So as it relates to, you know, density far, as you had said, you know, light, air, it's going to have a detriment to that. So I wouldn't be in support of it. I would be voting no, you know, based on that item, for example. Just continuing along, right, the uses that are permitted under commercial, right? Again, I mentioned lot line to lot line going up 42 feet. You mentioned car dealership. And again, there are a variety of things that could be done. With commercial, you know, again, you know, under special circumstances, this as well is going to have a negative impact on the neighbors as it relates to property values. And I know there's been some differing discussions, you know, or comments made in this hearing, but again, it's going to have negative impacts. So again, I would be opposed, you know, as part of my current position, which is a no vote, I would identify, you know, special circumstances, negative impact on property values, okay? Along with the one that I said before that, light and air. You know, look, I appreciate a lot of the comments that are being made by the applicant. Someone who had gotten up and, you know, spoke in support of it. People have gotten up and spoke in opposition to it. Some of the things that Commissioner Chanowski had said, some things that you had said. And I appreciate, you know, the challenges with split zone, right? And I appreciate that we want to do something with this. But we're limited in what we can do today, right? I mean, this is either an up or a down. We don't get to, and the solicitor can, you know, be my guardrails as he always is. We don't get to negotiate in this session the terms of what they can or cannot do on there, right? So this is an up or down. We're either going to rezone it to commercial or we're going to leave it as residential. And the risks of rezoning it to commercial are this could be any one of a number of things. Now, if we leave it as residential, and again, the solicitor can correct me if I'm wrong here, it's been used as a parking lot for 50 years. They can continue to use it as a parking lot, correct?
Probably, yes.
Probably. Okay.
I haven't looked into it at all.
Yep. But so I appreciate that there probably needs to be some consideration as to what to do with this parcel, but that's not our purpose today. I think this needs to go back to the Planning Commission, ultimately, you know, the Board of Adjustment to get the appropriate variances, because those are things that we can't discuss in this meeting today. Or I don't want to say we can't discuss in this meeting. Clearly, we can discuss them. We don't have the authority to grant those things in this session.
Mayor.
Let me just clarify something. When we say commercial can build lot line to lot line, actually, when they abut residential, there's a 5-foot setback. It's very minimal, but
Yeah.
But
So again, we're talking, you know, and Mayor, I appreciate the clarification on that, right? It's important that we have, you know, the accurate facts here or the accurate, you know, statements of the code. But again, we still are talking, you know, very close proximity, you know, going up, you know, at least 42 feet.
Thank you. Anybody else?
Yeah, I would just like a clarification was made and confirmed by the interim solicitor that it could continue to be used as a parking lot despite what happens with the rest of the property. I believe we've received conflicting testimony to that fact in the past.
If you listen closely, I said probably, and I haven't looked into it. So-
Can we ask the applicant for
Well, no, we're in
clarification?
public hearing. We cannot go back.
Gotcha.
We have a record.
So just to you know, continue my comment on that, right? So my position still would be, even if they, you know, taking my comment on parking, this is about taking it from residential to commercial. which provides them the ability to do any number of things.
I agree with that. And so let's say it didn't pass, there would be a site plan. We would address that issue, whether or not you could continue parking in there. So that's why I gave you probably. 'Cause I don't know. Perfect.
Thank you, Commissioner. Commissioner Gossett, go
Yes,
ahead.
thank you. I just want to appreciate all the comments that were made today and the background history of the property. Brings back some memories in that time also. But just to, as Commissioner Thier had mentioned, our purpose here today is address the change in the zoning as not the use of the land, not what is proposed for the use of the property. So it's zoning versus use. And just going back, and as our guiding principle is the CDP, and as the mayor had referenced, Chapter 4, Land Use and Annexation, one of the action items in there, 4-18, is ensure the city's land use plan and zoning code are drawn to avoid any adverse impacts by commercial development upon residential neighborhood. So that is what is in our CDP that guides us in what we have the ability to do. As the CDP, as I understand it, have been involved with that for several times, has the force of law. So that is a direction of what we have, and if it is stated to rezone something, then we have 18 months to act on that. As is noted, there is no call in the CDP to rezone this land. And I guess that's one of the things in hearing comments today, that this whole process started in 2018. And why then was not there a option or discussion during the development of the 2020 CDP to have this land rezoned in that area? This was the opportunity for the citizens. There were many meetings held, charrettes held by the Planning Commission. The CDP was actually held up almost a year and a half because of the coronavirus epidemic. So there was a lot of time for those individuals that had purchased the property or had this vision for the property that established in 2018 to make those changes, to suggest these changes be made in the 2020 CDP. There was no action on the applicant's part, to my knowledge of that anyway. And also the length of time that this has been going on, I understand also that a lot of that, well, I shouldn't say a lot of that, but a portion of that time was mentioned by Mr. Hutt, that the owner-landlord dispute that took some time to slow this down. So that is one of the contributing factors to the length of time, which I unfortunately, that's just the way it is. I also think that we don't look back at the history, as I said, is reminiscent of what have you, but looking forward is how that property is going to be used. The way the sessions work here is that if we were to grant this, there is no obligation on the applicant's part that they need to build what has been presented here. That zoning has been changed, and then that opens up to, as the mayor has described, quite a number of uses. And is, I think has been commented by one of the individuals that stated here, take this to the highest and best use. Well, at this point in time, this may be the highest and best use, but once that zoning change, if that were to happen, presents a whole different vision for that property, and another developer could come in and say, I've got a higher and best use for that, and here's X number of dollars more for exchange of that property. So again, we're looking at the proposed change in zoning, not the use, because the applicant has no authorization. I'm struggling for a word here, but they don't have to build what has been talked about today, in that sense. I also go back to, was on the Planning Commission for a number of years, and following the law versus what you feel is doing the right thing, this one decision still sticks with me that we made back in 1999 when there was a partitioning going on Laurel Street. And one of the budding neighbors, who had lived in that house for almost 40 years, there had been a partitioning taking place to the west side of her house, where a large home had existed on two lots for a number of years. The lot was partitioned, a new house had been built, and then the same thing was happening to her on the other side. And I still remember that comment from 1999, is they took my light away. So that is an adverse impact on the individuals that are experiencing this, and that has the potential, again, to have the same thing happening on our neighbors that are in a residential zone. And also the owners had full knowledge of this zoning when they purchased the property and could work through possibilities of making changes and what have you. But again, this goes back to the fact that we are looking at a zoning change, not as a use change, and I do think that this has detrimental effect on the neighborhood, as it were. Also the aspect of less congestion in the streets. That building has been basically sitting dormant for a number of years, but the projected use of that property as a hotel, how many of the rooms you're going to have, more comings and goings, daily check-ins and check-outs. So there's going to be more activity. There's going to be more traffic in the streets, more congestion, more surrounding the property due to that increase in the use of the property. So again, I think that is a detriment to the neighborhood and the neighbors that live there. I've had opportunity to think long and hard of this because we started this in November, actually started, as people were saying, 5, 6, 8 years ago. But just thinking about this and looking to the future, this is also going from a R1 to a C1. That's an increase of FAR, the floor to area ratio. And in R1, that's 0.6. In a C1, they can go to 2.0 in the tier 2 and 3, which is this aspect of it. They also, this is a reduction in the natural area of 50% in the lot area in R1 to 0 of natural area in a C1. Again, that's the impact. We look at pervious surface, rainwater, stormwater runoff. This has a major impact on that. So again, I just think this is looking at the zoning that was set in place by our forefathers when they laid out this town, that the commercial district is Rehoboth Avenue, and the ancillary streets are used for residential, either R1 or R2. So I just see that this is looking back early on, 100 years ago, 1878, when the map was laid out, to try to look to the future as to what we are could potentially have an impact on the future of Rehoboth Beach. And I do agree that the building needs rehabilitation. And as an owner, for it sit there in its condition for the past 2 to 3 years, I question that also. But also, the comment was made today about a property on Sussex Street going from 1.6 to 2.7, I believe was the quote. Well, you've got a residential lot right there. If property is so increase in value, be so great, why don't you build residential on what it's zoned as residential? You have that opportunity. There's money to be made in residential in the city of Rehoboth. So again, I'm just coming back to my comments, my thoughts, and how I look at this, again, change in zoning and the potential use that would be permitted if we go to a change in zoning. Thank you.
Thank you, Commissioner. When it gets to the point somebody wants to make a motion, like it be done in the affirmative, please.
Mayor, I'd be happy to make a motion, if I may, if you're ready. I make a motion to change the residentially zoned portion of 330 Rehoboth Avenue from R1, General Residential District, to C1, Central Commercial District.
And to adopt the ordinance as written.
And to adopt the ordinance as written. Thank you.
Second.
Guardrails.
I have a motion by Commissioner Patrick Gossett and a second by Commissioner Ed Chernowski to approve the, do you have it written out?
To change the residential zone portion of 330 Rehoboth Avenue from R1, the General Residential District, to C1, the Central Commercial District. And as the...
And adopt the ordinance as
written.
Is there any additional discussion by the commissioners? Yeah, just remember when you give your vote, we need to state the reasons or reference your earlier rationale. Did you have something you wanted to say first?
No, if it hasn't been seconded, I'll second it.
No, Ed seconded.
Okay.
With that, we'll do a roll call vote. We'll start with you, Commissioner Gossett.
Yes, thank you. For all the reasons stated, I've just stated, I vote against the pending ordinance to rezone the portion of 330 Rehoboth Avenue from R1 to C1.
And do you incorporate your prior comments into as the reasons of your vote?
I do. Thank you.
Thank you. Commissioner Markert?
I too vote no for obviously incorporating my comments from before, but I want to stress with regard to the CDP not really calling for this, and I just wanted to add that to the list of topics that I covered previously.
You may also, if you so choose, incorporate the comments of Commissioner Gossett also as part of your vote.
Okay, and I would also incorporate the comments actually from Commissioner Gossett and Commissioner Thier, if I may.
Thank you. Commissioner Thayer?
I as well vote no for the reasons I had previously stated, incorporating those comments that I previously made as my reasons for voting no. I also would like to incorporate the comments made by Commissioner Gossett and Commissioner Markert.
Commissioner Czerniawski?
Bear with me, mine's going to be a little bit longer since I'm a lone wolf and we've got slapped with the court remanding this once before. I vote aye. The applicant has applied for rezoning in good faith at the recommendation of the Planning Commission in January 2019, despite later changing its mind in 2021. That variances would be more appropriate. Furthermore, in good faith and effort on the part of the applicant, they offered to place restrictive covenants on the property that would be acceptable to the city. The age, the condition, and location of the property and its improvements make it ripe for redevelopment. Not only is it ripe, it will help maintain the character and suitability of our city and the needs we have, such as high-class accommodations with suitable parking. The redevelopment will help secure a better sense of health, welfare, and security of an area and a property that is dilapidated, often vacant, and a mostly unused parking lot, particularly dark at night. Furthermore, such redevelopment improves property values in the surrounding area rather than an unknown, dilapidated area of land. We received factual statistics that support this today. Split zoning is a bad practice. It is disfavored. It is a disfavored land use principle. It is widely accepted that when split zoning exists, the prime time to correct such a discrepancy is during redevelopment. I support the rezoning particularly because of the compliance with the comprehensive development plan, and I will provide a few examples. Quoted from the CDP, Rehoboth Beach is now and will remain a multi-function city or town within a town. It is a stable and inclusive residential community as well as an active seaside resort with a vibrant commercial district. Maintaining this balance will require a commitment to future development and redevelopment, both residential and commercial, reflect and compatible with the city's existing neighborhoods as well as its commercial districts. Existing, it is a word that is used a lot in the CDP. The evidence shows that the property has been used in a commercial manner for at least 60 plus years. We cannot ignore the fact that the CDP referenced existing character and use a countless number of times. Further to evidence commercial properties that already exist further southwest away from Rehoboth Avenue on State Road. Another example is quoted from the CDP, the city is a small 1 square mile community with opportunities for adaptive reuse and redevelopment of key properties. The city recognizes that there will always be a rolling life cycle to the use of buildings and acknowledge that there may be a future need for new tools to accommodate that change. Correcting mixed use when it is widely known as a bad practice, a tool we have is to correct that, and we should. The city works to protect key elements that set it apart from other beach resorts, encouraging environmental protection practices, and while supporting compatible development and redevelopment that helps preserve its status as a premier seaside destination and home to those seeking a traditional pedestrian-oriented small-town atmosphere and charm. Having a state-of-the-art hotel accommodations at a significant gateway which merges two of the city entryways to the city further supports that claim. In a matter, precedent has been set by its conforming use as a commercial property already. There has been no evidence that the current use has had any detriment or adverse impact to the area. And lastly, we have existing building code that has setback provisions to take into account the concerns of abutting residential properties and the protections of the Planning Commission site plan review. Thank you.
Thank you, Commissioner. And you stated your vote?
Yes, aye.
Aye, okay, very good. While Chapter 4 of the land use section of the CDP carries the most weight for me, or has carried the most weight for me, to avoid adverse impacts, commercial on residential. And following the Planning Commission recommendation to seek variances of the Board of Adjustment. However, I have said I believe that's I believe that resolving or remediating the split zoning trumps all this. And for those reasons and for reasons stated earlier, I am voting no, and so the motion carries.
Do you,
Oh, I'm sorry, I'm voting yes. And also for the reasons,
do you incorporate the reasons stated by Commissioner Chernaski?
correct, thank you.
Is that a yes?
Yes. And so the motion fails 3-2, and that's it for that. With that, we're going to recess for 1 minute, 2 minutes to set up for our next agenda item. Thank you very much. Oh, you're,
It's his project too.
all righty, we're back on the clock, and it is 12:02. Our next item of business today is in the matter of the Beachview Hotel, 8 Wilmington Avenue. Conduct a public hearing regarding a proposed ordinance to potentially change the residentially zoned portion of 8 Wilmington Avenue, tax parcel number 334-14.18-40.00 from R2 General Residential District to C2 Commercial Amusement District or to C3 Commercial Secondary District. Max, do you want to
Let's
introduce anything?
Yeah, let's deal with the formalities. So, and I got these from Ann. Public notice for the public hearing to amend Rehoboth Beach Zoning Map and the zoning district boundaries by rezoning a portion of the property located at 8 Wilmington Avenue from R2 to C2 or C3 was posted in City Hall on the city and on the city portal on January 7th. The public notice was published in the Cape Gazette on January 14th and January 17th, and in the Delaware State News on January 10th and January 14th, 2025. Notification specific to this rezoning request was mailed out to property owners within 200 feet. And can you confirm for the record that what I just read is accurate? Correct. And I'll just set this up with a little bit of discussion, and then I'll turn it over to the planning, or to Mary Ellen. There is this little tiny portion of this property which is zoned residential. It came up, Mr. Hutt's presentation, the concept plan to the Planning Commission, and upon looking at that, I looked at the comprehensive plan with Mary Ellen at the table, and we realized that this small portion is residential, and the comprehensive plan has it zoned resident. The comprehensive plan has it says it should be commercial, but it's actually zoned residential. So this is functionally a proactive rezoning, which you're required to do under the Delaware Code. So your actions today are either to amend the comprehensive plan and keep it residential, or to change it as the code requires into a commercial designation. So if you vote no, we'll have to take other steps. If you vote yes, it'll keep its commercial designation. And Mary Ellen, I know you put a report in, and if you want to discuss functionally what your recommendations are, what your department's recommendations are, that'd be great.
Sure, I'd be happy to. And if you could forward, or the mayor, I don't know who has control, to the AIR reports.
What am I forwarding? Oh, you're,
That's some maps. I would like to refer to the maps. There we go. Perfect. We can stop at that. Actually, we can go, do I have control or no? Would I be able to go up to the zoning map first? So as Max indicated, good afternoon, everyone. My original remarks said good morning, but now it's afternoon. I was asked to give a recommendation as to whether a 14-foot parcel located at 8 Wilmington Avenue, known as a beach, the property known as a Beach View Motel, should be rezoned as either commercial district designation C2, which is commercial amusement district, or C3. As Max indicated, the interim city solicitor, Max Walton, indicated, under Del Code 22C, Section 702C, the city is required to rezone lands in accordance with the comprehensive plan designation within 18 months of plan adoption. And as the application regarding the Beachview Hotel has revealed that the hotel property, there's a small portion, as indicated on the map here in the blue outline. The 14-foot parcel is on the Delaware side. That is currently zoned R2. And the commercial designation on the comprehensive plan map is, would you be able to go up to, I think the previous map, I think, is before this map?
Hang on.
where is?
We only have one map in the
Point
packet.
You only have one map in the packet? Really? Oh, goodness.
But I think we're ready to make a motion to
Oh,
rezone it. Like,
okay.
with all due respect to you, Mary, I
I'm
think
good.
we need to sort of.
I'm
I think
good.
We
Go
have
ahead.
all the information in front of us.
Actually, I'd like her to finish her presentation, if we could, Mayor.
Okay. Well, there was the comprehensive plan map, and I'll just verbally describe it. The comprehensive the comprehensive development plan map does designate this parcel as a commercial. And as such, therefore, this R2 map, this R2 residential designation is in contravention of the commercial designation on the comprehensive plan. By way of background, as we just, oh, there it is. Oh, perfect, thank you. So that little area there, the outline there, that's that parcel right there. And of course, I'm sorry, that just doesn't have a legend because I kind of scanned it in. So the red parcels are the commercial designation in the comprehensive plan. So by way of background, the owners of the Beachview Motel, as Max indicated, at the Planning Commission meeting on November 21st, presented a concept plan, and the owners plan to do an extensive renovation of their hotel. And the property currently sits, and if we can go back to the other map that has the three properties, the three designations. So the parcels of land on has three parcels of Rehoboth Beach parcels that have three zoning designations, C2, C3, and R2. The two City of Rehoboth Beach parcels at Front Wilmington Avenue is zoned C2, and on the easterly parcel C3, and on the westerly westerly parcel C3. The parcels at Front Delaware Avenue are zoned C2, and on the easterly parcel on the the commercial on the easterly parcel is C2. The westerly parcel is the R2 district zone.
I'm sorry, Mary, could you repeat the zoning classifications then for your frontage on Wilmington?
Of course, on Wilmington is C2. C2 is on the easterly parcel, and C3 is on the westerly parcel.
Thank you.
You're welcome. The 14-foot parcel currently includes the parking lot for the hotel, as you can see there. Thank you for outlining that. However, the renovation plans include expanding the hotel into that portion of the parking lot on the 14-foot parcel. So consequently, in order to move forward with the renovation plans, as well as to comport with the Del Code, as I just described, this parcel will need to be rezoned. So for the PERS 270 of the City of Rehoboth Beach Code, for C2, the purpose is to include these commercial areas on or adjacent to the boardwalk where enclosed spaces or amusements are on one of the uses permitted, and the uses are not restricted as to floor space size. The purpose for the C3, or the commercial amusement zoning district, is, for C3, is to include those commercial areas where certain uses are not permitted in buildings over a certain size. So the purpose of C3 is to more limit building size in the commercial district. A hotel, a motel, or inn is an allowed use in both C2 and C3 as Tier 2 uses. So the adjacent commercial parcels on the east, I already described that. So given that the current use is a hotel, which has a footprint of over 10,000 square feet, and the adjacent commercial lot for Beachview is zone C2, staff's recommendation is to rezone the residential zone 14-foot portion of 8 Wilmington Avenue to C2.
Questions of Mary Ellen?
Yes, if I may. Your I'm sorry. Under staff recommendation there on your agenda item report.
Yes, sir.
You make us, or a statement made, rezone the residential portion, et cetera, from R2 to C2. I don't I understand the concept there, but is there a rationale that decision was based upon?
Sure. The rationale is twofold. One is that the parcels, the adjacent commercial parcels on I think we have a zoning map on there. So adjacent parcels towards the boardwalk side are zoned C2, and the parcels on the Wilmington side are zoned C3. And so I think to comport with the area, I think it makes more sense and as well as the use of C2 is more appropriate for a hotel, given that a hotel has a larger footprint of over 10,000 square feet. And C3 is more appropriate is more geared towards uses retail uses and other commercial uses that are smaller in size.
I kind of I question that, right? So I'm not questioning the need to do the rezoning. And my question is probably a little more broad, and a little bit with what Commissioner Goss was asking her, what's the rationale, right? Because when you look at this parcel, you can make the argument either way, right?
Yes, you can.
You've got, again, I don't want to use the term split zoned. I mean, it's kind of subzone or whatever we term it as, right? They're going to continue to be, let's just use the term split zone, right? It's going to be split zone. We're going to have part of the property is going to be 2, part of it's going to be 3. We're only considering that small strip today, so that's the only thing that we're changing, right? Everything else remains the same. So, I could look at this map and say, okay, you've got the first 4, let's call them the first 4 lots from the boardwalk, right? Counting right to left, right? Clear delineation after that 4th lot, C2, right? If you look at a broader zoning map, and again, I may be using this term incorrectly, but it appears to be spot zoned, right? We've got some...
Bring that down so we can see it all.
Yeah. So we've got spot zoning for C2 for an amusement district, which was clearly intended to support amusements, right? Funland, whatever the case may be, open air, height, amusement, so on and so forth. When you use the rationale of hotels, I'm not sure, I mean, if we look throughout the rest of the city, where all the rest of the hotels are, they're all C3. So I'm not sure how that rationale of, oh, well, this is going to be a hotel, it should be C2, when C2 was really intended to support amusement areas. So again, I'm not necessarily following your rationale. I think one of the things that, and I've spoken with the city manager about this before, is that, I feel like when we're talking rezoning in particular, we need to be very meticulous in our rationale, right? Because this is part of the CDP and we've got to follow the CDP. And in the agenda item report, I was really expecting to see your rationale for C2 versus C3 since we specifically spoke about that a month ago. But I kind of want to come back to, and I guess it's getting down to a very specific question, if the rest of the city and where all the other hotels are is zone C3, why isn't that good enough for this, which is essentially a 14-foot strip of land when they've got hotel on another piece of that parcel that's C3? So just, again, walk me through why you think it being a hotel means it should be C2 versus C3, which supports the rest of the hotels in this community.
Sure. So I look at, so to me, spot zoning is putting, rezoning a property that doesn't have any other appropriate adjacent uses around it. So here, there's an adjacent use of C2. So to me, from a planning standpoint, it makes more sense to have a use that is adjacent to the character of the area, which the character of this area right here is C2. So, that's my rationale to that, is you have to look more at the character of the area in which you're rezoning it to. So the character of this area is more of the amusement areas, and so it more fits that character of this area.
And Commissioner Thier, if I may, so specifically, I believe that because Delaware Avenue has no C3 on it, that's also another reason
yeah, of course.
the staff recommendation is C2, because it is adjacent to it. There is no C3 on Delaware Avenue, but you can make the case because directly above on Wilmington, it is directly adjacent with C3. So, you know, either way, hotels are permitted uses in both. It just depends which zoning district you feel is appropriate.
Mayor?
Mr. Hutton, I'm going to get to you in a minute, and I'll give you the opportunity to speak. Commissioner Good?
Oh, well, I was based on a hardship situation, in my view, on this, that, you know, what could you put there if it continues to be zoned R2? Maybe a dog run, you can't even fit like a mini house on that, you know, that narrow piece of land. So I was, unless the council for the applicant needs to speak, I'm ready to make a motion, and I think the C2 has a lot of justification rather than going with C3. So I'd like to make a motion.
Suzanne, let me cut you off. This is a public hearing, so we want to,
You gotta close the public hearing, and then you can make your motion immediately after that.
but before that, I want to give Mr. Hutton an opportunity to speak. So I'll come to you in order in a minute. Can we go ahead?
More questions?
Are you finished, Mary Ellen?
Yes, sir, unless there's any more questions from the mayor and commissioners.
Let's let Mr. Hutt make whatever presentation you'd like. You can respond to Commissioner Thier's question or do your thing.
Thank you, Mr. Mayor. For the record, still David Hutt. I'm with the same law firm as earlier today. In this application, I'm representing both the owner of the property, which is Cooper Simpler Associates LLC, as well as the operator of the property, which is Seaboard Hospitality LLC. And just to sort of bring us up to where we were, Mr. Walton's correct. There was a conceptual review of the Beachview Hotel and the planned renovation of that. And one of the items that was highlighted during that conceptual review was the fact that there is this residentially zoned portion of the property. And of course, in order to move forward and be able to apply the code in a meaningful manner to that residentially zoned portion would have to be modified and adjusted. As you know, I guess I'm the date guy, but I went back to the deed from 1940. That's the first deed that I saw that transferred all of Lot 5 and 14 feet of Lot 7 to the owner at that time. So for 85 years, almost 85 years at this point, all of Lot 5 and 14 feet of Lot 7 have been together as one piece of land, and then ultimately the pieces that are on Wilmington Avenue were added to that thereafter. With respect to the ordinance that's in front of the mayor and city commissioners, with respect to C2 or C3, the applicant's request would be C2, agreeing with the rationale that was put forth by the city planner. It is consistent with the zoning classification on parcel 5, which is the primary piece of this, and just extends that another 14 feet. And not only, of course, is it consistent with Lot 5 on that block, but of course it's also consistent, and this was just referenced by the planner, with Delaware Avenue. That is the consistency with Delaware Avenue. And so extending that back another 14 feet is the applicant's request so that the current use is compliant with the zoning on the property. Two other comments. One is that a lot of there was a comment made that hotels are on C3. I would say hotels are on C1 in the city. 1 Rehoboth, 3 Rehoboth, those are on C1 zoning designation. And so I'm not going to say there aren't hotels on C3, but some of the projects that you have right now in front of the city that you're considering are on C1 lands. And the other thing I would say is there's an argument to be made that if that becomes C3, it's closer to spot zoning because there would just be that one spot of C3 on Delaware Avenue at that point. And spot zoning is, again, one of those things that the law disfavors heavily. And so, again, because it's commercial, Mr. Walton could probably make a good argument that it may not be spot zoning, but it really would be, and I think the city manager pointed this out, it'd be the only C3 that existed along Delaware Avenue. So for all of those reasons, again, I'm happy to answer any questions you may have, but the applicant, I'm not the applicant, the city staff, I'm not trying to steal your thunder, Mr. Walton, the owner of the property and operator of the property would request that it have a C2 zoning designation.
Understood, but whether or not it's zoned C2 or C3, it's not going to impact your project that you're contemplating.
That's correct.
Before I go to the public hearing, are there any further comments or questions for Mr. Hutt? If not, then this is a public hearing. Open the public hearing. Walter, you're the only one member of the public. There being no other members of the public, we will now close the public hearing and bring it back to the commissioners. Do you have anything you want? So we can open for additional discussion or entertaining a motion. We do have 2 ordinances in front of us.
I would like to make, Mayor,
Commissioner Good, go ahead.
I would like to make a motion to adopt an ordinance to amend the Rehoboth Beach zoning map referred to at Chapter 270, Section 270-7 of the Municipal Code of Rehoboth Beach, Delaware, and the zoning district boundaries as referred to at Chapter 270, Section 270-8 of the Municipal Code of Rehoboth Beach, Delaware, 2001, by rezoning a portion of the property located at 8 Wilmington Avenue, Sussex County Tax Parcel 334-14.18-40.00 from R2 General Residence District to C2 Commercial Amusement District.
Do we have a second?
Seconded.
We have a motion by Commissioner Suzanne Good and a second by Commissioner Mark Saunders to amend the Rehoboth Beach zoning map and adopting the ordinance before us. Is there any further discussion?
For those who, we need to state adequate reasons in the record for the vote, but there's an easy way here too. If you wanted to, you could say for the reasons stated in the planning department's report would be sufficient reasons in the record. And that would get us by the requirement.
So should I should
Just
now
when you-
say- I mean, my reasons have to do with common sense, with the fact.
you can-
Well, you can give that when you vote.
Yes, you can say whatever you want. I'm just saying if there's an easy way to make sure you have all the stuff in there that you need to.
So I'd like to keep going around the table here. I'd like to do a roll call vote with Commissioner Markert.
I vote aye for this. I think the rationale is it's in keeping we're trying to maintain some level of consistency with regard to the zoning in the commercial district on Delaware Avenue, and I think there's benefit to that. The fact that that this is in agreement with the petitioners, and it just seems like a sensible thing to do.
Couple questions for you.
Sure.
Do you agree that the ordinance is made with reasonable consideration as to the character of the district and the particular suitability of uses?
That's precisely what I feel.
And do you agree? And do you agree and adopt the statement set forth in the planning department's report?
I do. Thank you.
Very good, thank you. Commissioner Thier?
Aye, for the reasons as set forth in the,
Planning Department's report or by Commissioner Mackert.
yes, or by Commissioner Marker, yes.
Commissioner Saunders?
I also vote aye for the reasons given by Commissioner Markert as well as by the City Planning Department.
Commissioner Good?
I vote aye because I think we should not have an environment here in this city where we impose a hardship on owners and prospective buyers when purchasing land, which is extremely expensive on a per square foot basis. This is in the ocean block, and we want to make it practical for them to have at their disposal reasonable building code provisions. And so I absolutely vote aye, and I hope this carries.
Commissioner, do you believe the ordinance is made and with a view of conserving the value of buildings and encouraging the most appropriate land throughout the municipality?
I do, having done another walkabout on both Delaware and Wilmington Avenues yesterday. There is because of the Ryans and other properties in proximity. I think this is in keeping with the character and will not measurably alter the character of the city, and including this particular block.
Two more quick questions. Do you believe the ordinance is made with, and I believe by your statement, do you believe that the ordinance is made with reasonable consideration as to the character of the district and particular suitability for particular uses?
I do, and C2, I think, is restrictive enough that we're not going to see a gas station going in on that narrow strip. I'm not sure of the I'm not sure gas stations are allowed anymore in this city, but yeah, I'm comfortable with it on all levels. Thank you.
And one more question. Do you believe it's in accordance with the comprehensive plan?
The comprehensive development plan, for better or worse, has made some good recommendations and some horrible ones, including a canal boat dock, which is supposed to be a commuting means for people. So, I'm not comfortable using the comprehensive development plan as a blueprint for how we make decisions, to be honest.
Fine.
So, is it in keeping with a CDP that I think is fundamentally flawed? Maybe, but I can't really answer that question.
All right, thank you. Commissioner Srnowski?
I vote aye, incorporating the building unlicensing department's report.
Commissioner Gossett?
I vote aye, incorporating the building licensing recommendations and also comments made by fellow Commissioner Markert.
And the chair votes aye, also making mention of the city planner's recommendation and in agreement with Commissioner Markert's rationale. With that, the vote is 7-0 and the motion passes unanimously. All right, we'll go on to the next. The next item of business, consideration and possible vote on adoption of a resolution setting a public hearing to amend section 270-82 relating to the building inspector's authority to interpret and enforce chapter 270 zoning, alternately called the BI version. Can we combine these two? I'd like to
Well, do two separate.
do one at a time. So the goal here, though, is to adopt both resolutions, setting two public hearings, and then that discussion could take place concurrently. Right?
With all the ordinances, correct.
With all in it. And because there is a date on there, Ann informs me that if we pass this resolution today, one or both, preferably both, that the earliest we could see this on the agenda is around Friday, February 28th. Are you open on that day? Check your calendars. That is, would be a morning session starting at 9 o'clock. There is a planning commission meeting in the afternoon, so that's probably apropos to take on this topic in the morning. Now, that's the earliest. We could also or do a special meeting the week of the 3rd, or I would suggest going to the 10th, although the 10th doesn't work either because we've got a budget meeting and then a workshop meeting. So how does everybody fare on the morning of the 28th? Are you all right?
I am.
Yeah, 28th doesn't work for me.
I
doesn't
may
work for
have a
me either.
problem with that as well. March 10th, well, March 11th is not possibly under consideration to be, in proximity to the workshop and budget meeting on the 10th.
It could be. Everybody check March 11. Max, well, I want to start with Max, though. March 11th. That'd be at 9 a.m.
I'm okay.
Mark, you're okay. Suzanne, you're okay. Ed, you're saying, I'm okay. He's okay. You're okay. Bunky, and you're okay.
Yeah, I think so.
Okay, so,
9 a.m.?
yes, so whoever makes the motion, it would be for 9 a.m. Tuesday, March 11th.
Mayor, before we make a motion on these resolutions
Yes.
as presented, I had a request.
Okay, go ahead.
Okay, I would like to amend both resolutions, we're going to be considering both of them, to prohibit the city from hiring attorneys either for the Planning Commission or for the Board of Commissioners. On January 23rd, taxpayers were suffering having 2 attorneys being paid several $100s an hour each. The Planning Commission budget alone is anticipated to be $160,000 in legal fees
Suzanne,
this year.
pause a minute, Suzanne.
So-
I want to make sure they understand. I know what you're talking about. I'm not sure they understand that you're talking about dismissing or not inviting the attorney, either the Planning Commission attorney and the max to participate in that. So we would be
In the public
without
hearing.
lawyers. So
It's
I
in
wanted to
public
make sure that
session.
that was
Right,
clear.
it's in public session, there are no FOIA violations, so there's no particular need to have counsel. We're paying for 2 legal counselors. Many of the planning commissioners are trained attorneys. If someone sees, thinks there's some risk of some breach of legal rules, which I think is unlikely, maybe at that point, someone might call for a hiatus in the session. However, I think, in general, this is just too important for this city. When we are pretending that by borrowing $5.5 million, we've shored up the budget for 2 years when we were supposed to pay for that out of,
Suzanne,
revenue.
Suzanne,
So we need to start saving money.
Suzanne, you're out of order.
Okay,
You're
we
off
need to,
topic.
I would like to save taxpayers' money. The January 23rd discussion, which involved the same 2 parties, the city had 2 attorneys there the entire time, running the clock. In fact, they have an incentive in many ways to run the clock because the meeting went for, I think, 3 hours and 50 or 55 minutes. And I have faith that the planning commissioners and the city employees can hold this public hearing without legal counsel holding their hands for several hours.
Suzanne, I think that's a horrible idea. Of all the meetings we have, public hearings, I think necessitate having attorneys there. This is really not a topic apropos for this. In front of us, we need to take care of this business and adopt these resolutions.
Mayor, if I could.
And if there's any other discussion, that should happen after these resolutions are considered.
Well, maybe Mr. Tedder could give us a figure for how much this 2.5-year discussion between the Planning Commission and the building inspector has cost taxpayers, I believe it's well in excess of $100,000 in legal fees alone.
I'm gonna jump in on just the procedure. You made a proposal for today, which I think is apropos to the setting of the resolutions, right, for the public hearing. And you have made a proposal or a motion, I can't remember how you phrased it, but let's say it's a motion. So you make that motion, that no attorneys attend that, and then if there's a second, then you can vote on it because you're seeking an amendment to the motion. The other stuff you can discuss with, with the city manager at another time, but that, because that's not on the agenda. But make your motion, and then we'll see if
Right.
there's a second, we'll go from there.
Yes, I'm making a motion to amend both of these resolutions, which will be under consideration, that the public hearing be held without any taxpayer money being spent on legal counsels. If the planning commissioners themselves want to engage the services of an attorney with their own money, I'm not
Suzanne, you
stopping.
made a motion.
Okay,
It's now
so
on the
that's the
floor.
motion
We want to see
for
if,
the hearing, right, for the public hearing.
the motion's made. Let us act on it. Is there anyone that wants to second that?
Yeah, Mayor, so I'm not seconding it. I'm probably slightly different version, or maybe it's not even a different version because we're going to go through this
Well,
process
we wanna
anyways.
act on
So I agree with a lot of what Commissioner Good has said, related to legal fees and, how much time we've spent on this, and we're going to spend more time on it. I feel as though we just spent a number of hours a couple of weeks ago having a joint meeting. And I think the best thing, what we should be doing today is moving forward with one of the two motions for a public hearing. That would then, I think to Commissioner's good point, would eliminate the need for, attorneys and probably make that meeting much shorter. And if we do have attorneys, it would certainly make it much cheaper. But I think that's the discussion we're about to have anyways, is do we move forward with both or do we move forward with one? I would prefer that we just move. We've had plenty of discussion on this, going back multiple years. I think the best thing to do right now is to try and move forward with just one motion, have the public hearing, and then go forward from there.
And that's fine, but we need to finish the business there first. There's a motion on the floor. If there's not a second, then it dies. Is anybody willing to second it? Hearing none, then the motion dies. So I would like to entertain, again, one or both resolutions. My recommendation is you schedule both public hearings so that if one fails during the session, then we've got the other one to fall back on, and it's done at that next meeting. So I would entertain a motion to adopt the resolutions before, we're only talking about the BI version right now.
Ask for a motion.
So is there anyone willing to make a motion?
I move that we set a resolution setting a public hearing related to amending Section 270-82 related to the building inspector's authority to interpret and enforce Chapter 270 zoning, and this is the BI version. And for a public hearing set March 11th at 9 a.m.
Second.
We have a motion by Commissioner Ed Chernowski and a second by Commissioner Suzanne Good to adopt a resolution in front of us proposing that a public hearing be held on March 11th, 9 a.m. In the matter of building inspector's authority to interpret and enforce Chapter 270 zoning, also known as the building inspector version, BI version. Is there any further discussion? If not, I'll do a roll call vote. Commissioner Thier?
No.
Commissioner Saunders?
No.
Commissioner Good?
Aye.
Commissioner Chernowski?
Aye.
Commissioner Gossett?
No.
Commissioner Markert?
No.
And the chair votes aye, but the ayes fail. And so this is not in consideration. With that, then we will go to the next item of business, which is kind of the mirror version of this, consideration and possible vote on adoption of resolution set up a public hearing to amend section 270 relating to building. To the, yeah, this was duplicated. Planning, relating to the planning commissions. Are you comfortable moving forward with this? Planning commission's authority to interpret and enforce Chapter 270 zoning PC version. That, by the way, all righty. Is there anyone that would like to make a motion on that one?
Mayor, I'd like to make a motion that, to bring forward a resolution to set a public hearing on, is this the right, section 270-82 relating the building inspector's authority to interpret and enforce Chapter 270 zoning,
In addition, there's one for 236
as well as addition to section 236
regarding the planning commission's authority.
regarding the planning commission's ability to interpret, authority to interpret and enforce.
Is there a second?
Second.
We have a motion by Commissioner Patrick Gossett and a second by Commissioner Mark Saunders to adopt a resolution setting a public hearing on March 11th, 9:00 a.m. On the subject of amending the code relating to the Planning Commission's authority to interpret and enforce Chapter 270, also known as the PC version. You okay with that? Is there any additional discussion?
Yeah, Mayor, I just want to say that I'm incredibly disappointed with my colleagues. It is incredibly disingenuous, and the whole point of a public hearing is to hear all points of view and to make proper consideration. And taking one of the options out of the mix before the public hearing is even said is, well, it's just bad government and it's disingenuous.
Thank you.
And I will not be attending the meeting if we are not considering all options.
Thank you. Any other comments?
Mayor,
You have a comment before
I
the
fully
vote?
support Commissioner Shanowski, and I likewise, I'm actually a bit shocked that, I thought the hearing was to allow the public to express their preference between the authority being, given to the planning commission or the building inspector. So it seems we're hastily jettisoning the building inspector version, but I think all of us thought that both, exactly as Commissioner Shanowski just stated, we thought that both would be options at this public hearing. So there's something wrong with, we were sort of given information that the public hearing was in order to evaluate both resolutions, and now, all of a sudden, one's been yanked. I think something went wrong with the communication, and something's wrong here.
Thank you. We'll do a roll call vote. Again, the motion is to set a public hearing on March 11th, 9:00 a.m. in this matter. Commissioner Saunders? Aye. Commissioner Good?
No.
Commissioner Sernowski?
No.
Commissioner Gossett?
Aye.
Commissioner Markert?
Aye.
Commissioner Thier?
Aye.
And the chair votes aye, and the motion's carried 5-2, setting the public hearing as noted. With that, we'll go to citizen comment. Walter? Nothing. There's no other members of the public here. This meeting will be adjourned at 12:46 p.m. And I want to make sure we note that at 12:02, Commissioner Saunders and Good joined us. Thank you. Thank you, everyone.